Look, everyone calm down. It won't be time to panic until they start arresting the judges. Well, crap, they started arresting the judges. The Trump administration has been pretty open about its war on the judiciary, but last week it took a huge, almost unprecedented step forward in an intimidation campaign against judges.
Who gets to make the call? Is it the guy whose name was on the ballot, or is it some bureaucrat? Is it the guy who got 77 million votes or some district judge?
Federal officers charged two judges, Judge Hannah Dugan of Wisconsin and Judge Jose Joel Cano of New Mexico, with crimes related to obstructing federal immigration proceedings. Now, these arrests were staggering, but what's even more gobsmacking is that in ordinary times, an ordinary presidential administration probably would have kept quiet and allowed these cases to play out in the criminal justice system. But we don't have an ordinary president, and we don't live in ordinary times. Instead of letting these cases work their way through the courts and allowing a jury to make an unprejudiced finding, the Trump administration just skipped ahead to the guilty finding and politically motivated gloating. Kash Patel rushed to Twitter to publicize the arrest, despite the fact that DOJ guidelines on handling the media prohibit the spectacle of the judge being perp-walked. And that's probably one of several reasons why Patel deleted his tweet. Assistant DHS Secretary Tricia McLaughlin proclaimed that the Trump administration was going to continue to go after these activist judges.
We've seen these activist judges trying to subvert the will of the American people. This is just beyond the pale. We are going to continue to go after these activist judges.
Attorney General Pam Bondi said that these judges are deranged and that the administration will fine them.
They're deranged is all I can think of. I cannot believe, I think some of these judges think they are beyond and above the law, and they are not. And we're sending a very strong message today. If you are harboring a fugitive, we don't care who you are. If you are helping hide one, if you are giving a TDA member guns, anyone who is illegally in this country, we will come after you and we will prosecute you. We will find you.
And President Trump said the quiet part out loud.
We have hundreds of thousands of people that we want to get out of the country, and the courts are holding us back.
And despite the administration's confident assertions of Judges Dugan and Cano's guilt, it's worth noting that the only facts we have available to us right now are from the government's charges against the defendants and the news media reports on their arrests. None of this has been adjudicated by a judge or a jury, and there hasn't yet been a trial or finding of guilt. And as we've highlighted a lot in recent videos, the process of fact-finding and adjudication is important. And of course, anyone who's ever watched an episode of Law & Order knows that at the start of a criminal case, the government often makes a lot of accusations. Those accusations are laid out in a criminal complaint, but during trial, the accusations have to be backed up by actual evidence and witness testimony. The government then has to show that it has met all the legal requirements, the elements of the criminal statute, in order to prove guilt beyond a reasonable doubt, and then a jury has to make a guilty finding. That's how we learn what's true and what's an unfounded accusation. That's why due process is essential. For now, though, these cases are in early stages, so the details we're discussing here haven't actually been proven, they're just accusations. But even based on the government's own accusations, these cases are unbelievably thin and possibly exonerative. And frankly, because of the implication and the chilling effect on the judiciary, it's crazy that these cases were ever brought in the first place. Now, Judge Hannah Dugan has served as a circuit court judge in the Wisconsin State Court for Milwaukee County since 2016. On April 18, 2025, she was set to hold a hearing for Eduardo Flores Ruiz. Flores Ruiz is an undocumented immigrant from Mexico who had received an order of removal in 2013 and had subsequently been removed to Mexico. Sometime between 2013 and 2025, he had returned to the United States without permission. He was scheduled for a hearing before Judge Dugan because on March 18, 2025, he was charged with several counts of battery in Milwaukee County Circuit Court. The battery charges stemmed from an alleged physical fight with his roommate over Flores Ruiz playing loud music in his home. And according to the criminal complaint, Flores Ruiz had also struck a woman who tried to intervene in the fight, which resulted in a domestic violence charge. On the day of his April 18th hearing, 6 agents, an ICE officer, a CBP officer, 2 FBI special agents, and 2 DEA special agents were at the courthouse to arrest him under their immigration authorities. They'd apparently seen his name on the court's docket, so they believed it would be easy to apprehend him when he showed up for the hearing. When the plainclothes officers arrived at the courthouse, they identified themselves to the shift sergeant and discussed their plans to arrest Flores Ruiz. They were told that they had to wait until after Flores Ruiz's hearing, so they assembled in the hallway outside of Judge Dugan's courtroom. According to the government's filings, one of the local public defenders recognized the officers and informed Judge Dugan's clerk about their presence in the hallway. The clerk then reported this to the judge, who declared that she was going to call the chief judge and left the courtroom. Judge Dugan, along with another unnamed judge, angrily confronted the officers in the hallway. Now, Judge Dugan hasn't spoken publicly about her motivations, but she had good reasons to be angry about ICE's presence in the courthouse. By arresting immigrants who are complying with lawful orders to appear in court, the administration is actively disincentivizing people, including not just immigrant defendants, but also immigrant witnesses, from showing up in court. So conducting regular sting operations when people show up for court makes it much harder for judges like Judge Dugan to do their jobs. And ICE's presence in the courthouse was not an accident. News reports indicate that ICE has arrested 2 other people at the same courthouse in the past 2 months. In the government's filings, FBI agent Lindsay Schlomer states outright that law enforcement routinely executes warrants and makes arrests in public areas of buildings like the Milwaukee County Courthouse. Special Agent Schlomer admits that the agency does this because the public court dates allow law enforcement to know where and when they can find the immigrant they want to detain. And immigration officials have been doing similar things when immigrants show up dutifully for their immigration check-in appointments. Last week, 2 mothers and their young children were picked up at their regular immigration check-ins, then quickly deported to Honduras. And you can see the problems here. If people start reasonably fearing that they will be picked up by ICE when they show up for court dates or immigration check-ins, they will stop showing up for those appointments. So here it looks like Judge Dugan attempted to protect the integrity of her courtroom by asking the law enforcement officials if they had a warrant, and when they informed her that they had an administrative immigration warrant, which we'll talk about in a second, she told them that they needed a judicial warrant. It's important to understand the distinction between the 2 types of warrants. A judicial warrant is authorized by a judicial court. It can be either a state or federal court, but it has to be signed off by an actual judge. Judicial warrants can authorize a seizure, arrest, or a search. A judicial warrant can permit law enforcement officers to enter a private space like an office or a home, and in order to obtain a judicial warrant, law enforcement must demonstrate to the judge that there is probable cause, that is, a reasonable basis for believing that a crime may have been committed or that evidence of a crime is present in the place to be searched. An administrative warrant, on the other hand, in an immigration context, is issued by an immigration judge or an immigration officer, who are members of the executive branch and are not Article 3 judges. It cannot authorize a search, only an arrest or a seizure. An administrative warrant does not permit officers to enter a private space, so the arrest or seizure must be conducted in a public space. And it's controversial, but ICE agents do not need to meet the probable cause requirement in order to obtain an administrative warrant. And in Judge Dugan's case, the law enforcement officers did not have a judicial warrant. After they confirmed this and offered to show their administrative warrant, Judge Dugan instructed them to speak with the chief judge. And 5 of the law enforcement officers were escorted to the reception area for the chief judge's office. One of the DEA special agents, who had not been recognized, remained outside in the hallway. Now, inside the chief judge's office, the ICE officers showed the unnamed judge their administrative warrant and credentials. The chief judge's clerk got the chief judge on the phone, and the chief judge advised the ICE agent that ICE enforcement actions could not take place in courtrooms or other private locations within the building, but could take place in hallways because those are considered public spaces. Now, according to the government's complaint against Judge Dugan, while the law enforcement officers were in the chief judge's office, Judge Dugan expedited Flores-Ruiz's proceedings, then directed Flores-Ruiz and his attorney to go out the back jury door instead of the door that led to the main hallway where the law enforcement agents had been waiting. The courtroom deputy has claimed that usually only deputies, juries, court staff, and escorted in-custody defendants are permitted to use the back door. This back door, though, only led to the public hallway, where 2 of the agents were still waiting. So if this had been some kind of attempt to subvert the arrest, it wasn't a very good one. One of the agents in the hallway recognized Flores-Ruiz, got in the elevator with Flores-Ruiz and his attorney, and alerted the rest of the agents. The agents caught up with Flores-Ruiz in the front of the courthouse. And when the agents identified themselves, Flores-Ruiz tried to flee, and the agents intercepted him before he'd even crossed the street. Even Andrew McCarthy, a former federal prosecutor and conservative legal commentator, was critical of the way that federal agents handled things. Now, he first explained that he felt that the situation was due in large part to Milwaukee's status as a sanctuary city, meaning that generally the city would not voluntarily help out the federal government in immigration-related events, which, under rules of federalism, the state cannot be compelled to do or to be commandeered by the federal government. But notwithstanding, he was critical of the federal agents inserting themselves into the state courthouse. He wrote, quote, "Trust me when I tell you that the federal agents who planned to arrest Flores-Ruiz in the state courthouse would never have done the same thing in a federal courthouse. They didn't tell Judge Dugan or the chief judge of the court that they were coming. They didn't alert court security personnel or the local police. In the federal system, agents of the executive branch would have understood that they do not have carte blanche to conduct enforcement operations in a federal courthouse, the judiciary's turf. They would not conduct a planned non-exigent arrest in a courthouse without first ensuring that they had the cooperation of the chief judge, any judge whose cases might be affected, and the court security personnel. The Justice Department would grasp that if the federal judiciary believed that law enforcement agents of the executive branch were exploiting the court's administration of justice, it would not go well for the DOJ in the many law enforcement initiatives, search warrants, wiretaps, grand juries, trials, etc., for which they need the federal judiciary's assistance. Now, a good lawyer, and spoiler alert, Judge Dugan now has one, will also focus on the affiant statement that, quote, having received the above referenced information from DEA Agent A, other members of the arrest team scrambled to locate Flores Ruiz and arrest him. It's undisputed that Flores Ruiz ran, but why was there a mad scramble to arrest him if they had an administrative warrant that gave them the right to arrest him in a public area of the courthouse? The entire episode, starting with Flores Ruiz arriving in the courthouse and ending with his arrest, took 22 minutes, and they had eyes on him the entire time, according to the affidavit. So for the sin of ushering Flores Ruiz and his attorney out the back door into a hallway that led right back to the hallway where she'd seen the law enforcement agents, Judge Dugan is now being charged with 2 crimes, one of which carries a maximum sentence of 5 years imprisonment and $250,000 fine. Now, if you're also a state judge who's been arrested by the DOJ, you're going to want a good lawyer. But if you want a great lawyer, my law firm, the Eagle Team, can help. If you've gotten in a car crash, suffered a data breach, especially if you've got a data breach letter saying your information might have been leaked, or dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. And by the way, we don't get paid unless you do, so there's nothing up front. So just click on the link in the description or call the phone number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team. Yes, on April 24th, 2025, President Trump's Department of Justice charged Judge Dugan with 2 criminal counts, a violation of 18 U.S.C. 1505 for obstructing or impeding a proceeding before a department or agency of the United States, and a violation of 18 U.S.C. 1071 for concealing an individual to prevent his discovery and arrest. And the next day, on April 25th, 2025, the Trump administration arrested Judge Dugan at the courthouse. She was released the same day and is awaiting the adjudication of the charges. And by all accounts, she could have been requested to show up for the charges, but instead they made a point to arrest her at the courthouse. Now, 18 U.S.C. section 1505 states in part that, quote, whoever corruptly or by threats or force or by any threatening letter or communication influences, obstructs or impedes or endeavors to influence, obstruct or impede the due and proper administration of the law under which any pending proceeding is being had before any department or agency of the United States. Now, in an interesting twist, a lot of the January 6 defendants were charged with this particular crime, and recently the Supreme Court has made it more difficult to charge and prosecute people with this particular crime, taking a narrower view of these elements. But even before that, this would seem like a difficult case for the government to make against Judge Dugan. Judge Dugan did not engage in any corruption, threats, or force. Her alleged confrontations with law enforcement agents were well within the bounds of a judge attempting to protect the integrity of her courtroom and proceedings, and at no point does the government's criminal complaint claim that Judge Dugan was violent or threatening. Judge Dugan also does not appear to have any earnest attempts to obstruct or impede law enforcement's arrest of Flores Ruiz. She merely led him out a door that led into a private hallway that led him right back to the public hallway. So unless there are some other operative details that the government didn't seem fit to include in its filings, Section 1505 will probably be a difficult case to make. Now, the charges under 18 U.S.C. 1071 seem even less likely. Section 1071 states, quote, whoever harbors or conceals any person for whose arrest a warrant or process has been issued under the provisions of any law of the United States so as to prevent his discovery and arrest after notice or knowledge of the fact that a warrant or process has been issued for the apprehension of such person shall be fined under this title or imprisoned not more than 1 year or both. Now, there are 4 essential elements that the government has to show in order to prosecute Judge Dugan under the statute. 1, a federal warrant has been issued for the fugitive's arrest. 2, the defendant had knowledge that a warrant had been issued for the fugitive's arrest. 3, the defendant actually harbored or concealed the fugitive. And 4, the defendant intended to prevent the fugitive's discovery or arrest. Now, first, according to the conversation that law enforcement officers had with Judge Dugan, all that ICE possessed was an administrative warrant, which may not qualify as a federal warrant for the purposes of fulfilling the first element of the statute. And if Judge Dugan didn't believe that the administrative warrant qualifies as a federal warrant, then it would be difficult to prove that the second element, knowledge of a federal warrant, could be met. And the final 2 elements seem equally unlikely. Would a jury find that by directing Flores Ruiz out the door into the back hallway, Judge Dugan had, quote, actually harbored or concealed the fugitive? That seems unlikely since Flores Ruiz quickly returned to the main hallway where he rode an elevator with one of the law enforcement officers and was apprehended soon thereafter. Did the judge's actions amount to concealment when 2 government officers were in the 6th floor hallway with Flores Ruiz? They probably could have arrested him right then. Flores Ruiz went down the elevator with his lawyer and an ICE officer, and they knew Flores Ruiz was unarmed but did not arrest him. Instead, they alerted the other officers that he was outside next to the flagpole. 4 officers were waiting for Flores Ruiz, who then made a break for it. Judge Dugan was still on the 6th floor of the courthouse at that time. And it seems equally improbable that by directing Flores Ruiz out the back door, Judge Dugan intended to prevent his discovery or arrest, since she would have been quite familiar with the fact that the back hallway leads right back to the public hallway where she'd previously seen law enforcement agents. Now, the mens rea requirement for a violation of 10 U.S.C. 1071 includes 1, knowing that a warrant or process had been issued for the person's arrest, and 2, intending to prevent that person's discovery or arrest. The statute does not require that the defendant have the specific intent to prevent the person's arrest for all time. The major question was whether Judge Dugan was trying to prevent Flores-Ruiz from being arrested that day, as the government alleges, or whether she was trying to protect the integrity of her own courtroom. Judge Dugan has not issued her own statement, but here's what the government says, quote, Judge Dugan asked if Deportation Officer A had a judicial warrant, and Deportation Officer A responded, no, I have an administrative warrant. Judge Dugan stated that the Deportation Officer A needed a judicial warrant. Officer A told Judge Dugan that Officer A was in a public space and had a valid immigration warrant. Judge Dugan asked to see the administrative warrant, and Officer A offered to show it to her. Judge Dugan then demanded that Officer A speak to the Chief Judge. Judge Dugan then had a similar interaction with FBI Agent B and CBP Officer A. After finding out that they were not present for a court appearance and that they were with ICE, Judge Dugan ordered them to report to the Chief Judge's office. Now, this interaction is up for interpretation. It's arguable that the judge was trying to decipher whether it was a judicial or administrative warrant, which she could have thought dictated how they could legally respond to their request. And as we discussed, if it was an administrative warrant, then she didn't have to help ICE. What facts does the government cite to prove that she intended to help him evade arrest? Well, the affidavit says that she was angry, and that could be probative, but a judge can be angry at many different things. The most serious evidence against Judge Dugan hinges on the court's deputy insinuating that Judge Dugan made an exception to normal procedure to help him avoid arrest. The affidavit says, quote, according to the courtroom deputy, only deputies, juries, court staff, and in-custody defendants being escorted by deputies use the back jury door. Defense attorneys and defendants who were not in custody never use the jury door. The deputy also said that Judge Dugan was pushing his case through. The government reports that the, quote, arrest team interpreted to mean that Judge Dugan was attempting to expedite Flores-Ruiz's hearing. Hat tip to Marcy Wheeler, who identified many of these issues. As she notes, there are other witnesses to what happened that day who weren't interviewed, most notably the Chief Judge. And according to the affidavit, the Chief Judge was in the process of writing a policy on how to handle this very situation. Quote, the Chief Judge emphasized that such actions should not take place in courtrooms or other private locations within the building. Deportation Officer A asked about whether enforcement actions could take place in the hallway. The Chief Judge indicated that hallways are public areas. Now, this could be consistent with the distinction between administrative and judicial warrants and with how Judge Dugan handled the scenario. There's a lot we don't know here, like whether the Chief Judge told Judge Dugan that ICE was free to arrest Flores-Ruiz in the hall. If convicted, Judge Dugan would be sentenced under the U.S. sentencing guidelines, and realistically, the guideline range would be 15 to 21 months. Now, additionally, Judge Dugan will likely argue that she was acting within the scope of her official duties as judge. Judges have extremely wide latitude to control their courtrooms. Federal officers cannot commandeer state actors, and there's nothing inherently wrong or illegal about letting a defendant who was before her on state criminal matters leave the courtroom however she liked. I'm sure the federal agents would have liked for her to comply with their every request, but state officials are under no obligation to acquiesce. So I'm sure her argument will be that she was a state judge controlling her courtroom as she saw fit, and had no obligation to comply with anything the federal officers asked, especially in light of the administrative rather than judicial warrant, and that her actions in her own courtroom were official acts outside of the purview of the federal actors. Still, even if that defense is successful, leaving through the not regular door into a private hallway that eventually led back to the public hallway is not a good look. And as a criminal matter, the facts in Judge Dugan's case likely won't lead themselves to an easy victory for the Trump administration. And reasonable minds can differ on the actions of Judge Dugan. But if I may opine for a moment, what bothers me are the tag-along effects of arresting a judge. At best, it would be a marginal case, and you might think the charges are BS, or you might think that the judge was trying to facilitate the man's escape. But given the clear federalism issues between the state court wanting to control its own courthouse and the lack of notice from federal officers to either the particular judge or the chief judge, this smacks of retaliation and politics. And just as the DOJ has reams of regulations and procedures that must be complied with before they arrest a politician, if the DOJ were to move forward with arresting a state judge, you would want it to be the most ironclad dead-to-rights case you've ever seen. And however you feel, that's not this case. This looks like it's about forcing compliance and sending a message. So even as we now understand them, given the government's filings, the facts in Judge Dugan's case won't lend themselves to an easy victory for the Trump administration. During President Trump's first term, Massachusetts Judge Shelley Joseph was also arrested after the Trump DOJ accused her of helping an undocumented immigrant evade ICE arrest when he was in her courtroom for a hearing. The government investigated for a year before filing charges against her. The biggest difference is that Joseph helped the defendant leave the courthouse through a door that was not public. She also allegedly turned off recording devices in the court, with the implication that the defense attorney asked the judge to help the person escape. The defense attorney accepted immunity to testify against the judge, which helped the government prove corrupt intent. It also took ICE 2 weeks to catch the defendant. which seems like it makes this case very different from Judge Dugan's case. The Biden DOJ later dropped the charges against Judge Joseph in exchange for her promise to refer herself to the Massachusetts Commission on Judicial Conduct for a full investigation of her actions. And in December 2024, the Massachusetts Commission on Judicial Conduct filed administrative charges against Judge Joseph, finding that she, quote, engaged in willful judicial misconduct that brought the judicial office into disrepute, as well as conduct prejudicial to the administration of justice and unbecoming a judicial officer. Judge Joseph's actions, though, appeared to be more serious than Judge Dugan's actions. Whereas Judge Dugan simply directed Flores Ruiz to a different door that took him to the very same hallway where the immigration enforcement agents were waiting, Judge Joseph was accused of directing the undocumented immigrant to a building door that effectively permitted the immigrant to exit the courthouse and evade ICE arrest. The government also claimed that Judge Joseph instructed the court reporter to discontinue the court reporting, as Judge Joseph gave the immigrant and his attorney these instructions. But even those actions were seemingly not sufficient to warrant a criminal finding, only a charge by the state commission. But those charges were dropped by the DOJ, so it's unclear what's going to happen here. And the government will be facing a formidable list of legal foes in its battle against Judge Dugan. A stunning lineup of all-star attorneys have volunteered to represent her, including former U.S. Solicitor General Paul Clement, who was appointed by Republican President George W. Bush. But in the meantime, Judge Dugan has been temporarily suspended by the Wisconsin Supreme Court while the federal charges are pending. This isn't meant to be a punishment, no finding was made against her, but it will keep her from doing her job and likely make other judges more fearful. But another case in New Mexico might offer the administration a greater chance of an actual conviction against a judge. Now, in the New Mexico case, according to the government's filings, 3 undocumented immigrants were living with permission on the property that belonged to former Judge Jose Joel Cano and his wife Nancy Cano. The government received a tip that one of the men, a Venezuelan national named Cristian Ortega Lopez, was a suspected member of the Tren de Aragua gang and illegally possessed several firearms. The government obtained 2 judicial search warrants and searched Jose Cano's property in another location. And at the other location, they found several illegal firearms. Law enforcement arrested Ortega Lopez and, after interviewing him, concluded that one of his cell phones was unaccounted for. They executed another search on Jose Cano's home and brought Jose Cano in for questioning. According to the government's criminal complaint, while being questioned, Cano admitted that he had destroyed Ortega Lopez's cell phone because he believed it contained pictures or videos that would reflect negatively on Ortega Lopez, specifically pictures of Ortega Lopez with firearms. Mr. Cano's wife, Nancy, was also arrested after the government obtained a video call she had with Ortega Lopez while he was in the detention center. In the call, the government claims that Nancy Cano displayed Ortega Lopez's phone to him on the screen and offered to delete his Facebook account for him. Law enforcement has maintained that Ortega Lopez's Facebook account contained significant photographic evidence regarding the crimes he'd been charged with, including pictures of him with firearms, gang-related tattoos, clothing, and hand gestures. Agents executed another search warrant at the Cano's residence on April 24th to locate Ortega Lopez's 4th unrecovered cell phone. During that search, Joel Cano allegedly admitted to smashing the cell phone with a hammer 5 weeks prior because he believed it contained photos and videos of Ortega Lopez that would incriminate him. Judge Cano resigned from his position after the New Mexico Judicial Standards Commission initiated disciplinary action. Cano told the commission that the 3 men were asylum seekers who had asylum hearings scheduled. He also alleged that the 3 men traveled throughout the U.S. and made it through checkpoints without being detained. Though the fact that they made it through checkpoints is not the best indication that they were here legally. But regardless of whether the Canos reasonably believe that the men were legal, their actions are extremely serious. And obviously you can't destroy evidence, even if you're a judge or a former judge. In response to Jose and Nancy Cano's actions, law enforcement charged them both with violations of 18 U.S.C. 1512. Jose Cano was charged with tampering with evidence, and Nancy Cano was charged with conspiracy to tamper with evidence. Now, if it's true that Jose Cano admitted to destroying the phone in order to destroy evidence of Ortega Lopez's gang involvement, then the government may actually have a case here, but again, they will have to prove that in court. Here, given Judge Cano's position of public trust and his alleged action to destroy evidence, his sentence would start at 21 to 27 months with prison time required. But unfortunately, instead of letting the jury adjudicate the charges and staying focused on the destruction of evidence, the Trump administration has used Jose Cano's case to make a statement about broader immigration policies in sanctuary cities. In an official DOJ statement about the arrests of Judges Dugan and Cano, DOJ Deputy Attorney General Todd Blanche proclaimed, quote, "Sanctuary cities that shield criminal aliens endanger American communities. This Justice Department will not stand by as local officials put politics over public safety. Reckless sanctuary city policies create a sanctuary for one class. Criminals, those days are over." Which is interesting and unfortunate because neither of those cases were actually about sanctuary cities. But both of these cases seem to be the tip of the spear for a larger policy objective. In a January 2025 memo by Acting Attorney General Emile Beauvais, the administration proclaimed its intentions to, quote, "take all steps necessary to remove undocumented immigrants and prosecute them for crimes." Trump's DOJ indicated that it planned to do more vigorous prosecution for a long list of immigration-related crimes, including crimes that involved harboring or transporting undocumented immigrants. The administration went so far as to require prosecutors to do regular reporting to the DOJ on immigration enforcement numbers and to disclose to the DOJ all decisions not to prosecute. Now, we've talked a lot recently about how executive orders and DOJ policy memos aren't actually the law, but this is an example of where these kinds of memos actually have some real effect. Here, the administration took aim at sanctuary cities and state and local government officials who, in the opinion of the administration, stood between the administration and their deportation goals, arguing that, quote, the Supremacy Clause and other authorities require state and local actors to comply with the executive branch's immigration enforcement initiatives. Federal law prohibits state and local actors from resisting, obstructing, and otherwise failing to comply with lawful immigration-related commands and requests pursuant to, for example, the President's extensive Article II authority with respect to foreign affairs and national security, the Immigration and Nationality Act, and the Alien Enemies Act. The memo proclaimed that the DOJ intended to investigate and prosecute state and local officials who obstruct immigration enforcement. And Trump doubled down on this in his April 28, 2025 executive order on, quote, protecting American communities from criminal aliens. In that order, the administration reiterated its goal to, quote, pursue all necessary legal remedies and enforcement measures against sanctuary cities. So given the Trump administration's ongoing hostility toward any officials that don't genuflect to its draconian and questionably legal immigration policies, and its dislike of judges in particular, it's not surprising that the DOJ decided to go after Judge Dugan. But it's particularly interesting to see how the media has covered the arrests of both judges. The arrest of Judge Hannah Dugan in Wisconsin was so shocking that a whopping 620 sources covering it, with about 50% of the reporting coming in from the center, a little more than 30% from the left, and less than 20% coming from the right. And when you examine the headlines, you see some very different frames emerge that shape how readers interpret and understand the events that are unfolding. From the right, the most common theme is to refer to the migrant as an illegal immigrant and characterize Judge Dugan's actions as part of aiding an escape. Left-leaning sources tended to downplay his immigration status while describing the judge's actions as shielding him or helping him evade ICE. And then from the center, headlines typically frame the events around the FBI alleging that she had obstructed immigration agents. Now, the headlines you read first have immense power to shape how you understand the news. And that's why I like to see the news from as many angles as I can, with the help of today's sponsor, Ground News. Ground News is a website and app developed by a former NASA engineer on a mission to give readers an easy, data-driven, objective way to read the news. And right now they're offering LegalEaglets 40% off their unlimited access Vantage subscription. You can scan the QR code or use the link in the description to get a discount for a limited time. Because Ground News gathers related articles from around the world and across the political spectrum, so you can see the bias and compare coverage. Every story comes with a quick visual breakdown of the political bias, factuality, and ownership of the source's reporting, all backed by ratings from 3 independent news monitoring organizations. One of my favorite parts is their bias comparison feature, which highlights specific differences in reporting across the political spectrum. This can be especially helpful when reading stories from sources you've never heard of, where there's no telling who owns it or what agenda they might have. I also love their blind spot feature, which shows you stories that are underreported by either side of the political spectrum. Like the story of Judge Jose Cano of New Mexico that we also covered in the story. You can find the story using the blind spot feature, as over 80% of the coverage was from the right or center sources, with less than 20% coming from the left. This type of breakdown of political bias in the news media helps explain why we often talk past each other, and why some people seem hyper-focused on what to others seems like nonsense or fake news. But all this is why Ground News is my favorite way to get the news. And as a LegalEaglet, you can save 40% off the Ground News Vantage subscription by scanning the code that's on screen or clicking on the link down below. The subscription gives you unlimited access to every feature, including the Bias Insight tool and blind spot feed. And by subscribing, you'll support an independent news platform working to make the media landscape more transparent. So click on the link below or scan the code today. And after that, click on this link over here for more LegalEagle, or I'll see you in court.